We have more for your ears only. I'm Catherine Herzog.
I'm David Alpern with this quote from the news: a cyber Pearl Harbor. That was U.S. Defense Secretary Leon Panetta warning that foreign hackers could dismantle the nation's power grid, transportation, financial, and government networks. Also last week, the House Intelligence Committee warned American firms against doing business with two Chinese telecommunications companies suspected of ties to the Chinese military. Now this.
The number of cases reported has increased in the last several days. Not so much that we think that cases are occurring at an increasingly rapid rate, but we're probably doing a better job at finding them. So far, all the identified cases have received an injection from one of the three recalled lots from the New England Compounding Center.
Since Dr. John Jernigan of the U.S. Centers for Disease Control and Prevention spoke to the media last week, the meningitis epidemic linked to fungus-tainted steroid serum from a super pharmacy in Massachusetts has killed at least 14 people, sickened 185, and put an estimated 14,000 at risk in 23 states. It also brought to light a troubling mixture of economics, law, and politics that permits such pharmacies, called compounding centers, to operate without the strict government oversight Americans expect of medications they receive from reputable doctors and hospitals. Ironically, an international study of the steroid in question, methylprednisolone acetate, showed no proof it really reduces the causes of back pain for which it is prescribed.
As the epidemic spread, operations ceased at the New England Compounding Center in Framingham, Massachusetts, and the Ameridose LLC pharmacy in Westboro, which has overlapping ownership, its own history of alleged safety problems, and an executive who also sits on the state's Pharmacy Oversight Board. The two companies also used the same spokesman last week as the first civil suit was filed. State and federal investigations got underway, and legislators considered stiffer new regulations. To consider all this for your ears only, we're joined now by Boston Globe reporter Todd Wallack and Washington attorney Sheldon Bradshaw, former chief counsel for the U.S. Food and Drug Administration. First to Todd Wallack, welcome to our program.
Good to talk to you.
It seems both NECC and Ameridose have had past issues with Massachusetts authorities. What can you tell us?
It's true, and they've also had, both of them have had issues with the FDA as well. There have been persistent signs that they're trouble. Actually, a patient sued, or a family of a patient who passed away sued NECC years ago because he died of meningitis from a tainted shot that came from NECC. There was a warning letter issued to NECC in 2006. There was an FDA inspection of its sister company, Ameridose, in 2008 that found a number of problems, including shipping drugs out the door before the testing of sterilization was done and received. Not all the lots of drugs were tested at all. There was a recall in 2008.
And what about the presence of an executive from the co-owned companies on the state regulatory board?
It raises a lot of questions. So Sophia Pacetas is an executive at Ameridose, a sister company of the one that's been blamed for the meningitis outbreak. And she had actually at one time was president of the board of pharmacy, still on the board, and there are questions about why she was hired, whether she knew what was going on, whether her presence may have kept regulators at bay.
Boston Globe reporter Todd Wallack. Next, to former FDA Chief Counsel Sheldon Bradshaw. Thanks for joining us.
Thank you very much for having me.
Doctors, hospitals, even the U.S. Department of Veterans Affairs have ordered from compounding centers because of their low prices and the growing shortage of pharmaceutical supplies for America's aging population. On what grounds did the Supreme Court strike down FDA regulations over these pharmacies operating essentially as wholesale drug manufacturers?
Actually, the Supreme Court's decision was actually very narrow. The only issue before the Supreme Court was whether or not pharmacies could advertise their ability to compound. Congress prevented them from doing so, and the Supreme Court, rightly, in my view, struck that down as a violation of the First Amendment. Importantly, the Supreme Court did not call into question the FDA's ability to regulate compounding pharmacies as drug manufacturers, but instead the Supreme Court decision is very narrow and limited only to the question of whether or not Congress had the ability to prevent pharmacies from engaging in First Amendment activity.
So is there standing legislation that gives the FDA authority that it's not using? You've said that they do have some authority under a 1938 statute about this kind of activity. What is the situation with FDA authority?
Yeah, no, absolutely. The FDA has historically, both in the form of warning letters to pharmacies and in briefs in litigation, maintained the position that they have adequate authority to regulate this sort of compounding pharmacy under the provisions of the 1938 Food, Drug, and Cosmetic Act. And it's important, I think, to help your listeners distinguish between two practices. One, I would call traditional pharmacy compounding. That's part of the practice of pharmacy. That's regulated by the state. But drug manufacturing is regulated by the Food and Drug Administration. Here, when we're talking about the compounding done by the New England Compounding Center and similar compounding pharmacies, that activity is not traditional pharmacy compounding, and I'm happy to talk about that. It is clearly drug manufacturing that they're engaged in. And as drug manufacturers, they can be regulated by the FDA. There's no question, at least based on past statements and actions of the agency, that the FDA has complete authority to regulate drug manufacturers.
Is it not going about that aggressively? Have there been criminal actions under either the more current law or the 1938 law?
Well, there certainly could be. Under the 1938 law, it is actually a criminal act to introduce into interstate commerce an unapproved drug. It's also a criminal act to introduce an adulterated drug, and it's a criminal act to introduce a misbranded drug. So the FDA, if it wanted, could bring criminal charges against the New England Compounding Center because they violated all three of those prohibited acts, which are set forth in the Food, Drug, and Cosmetic Act.
Well, given the spotty state regulation, is the need more for new legislation to reassert federal oversight or simply for more aggressive use of the 1938 law to investigate and regulate these compounding centers when they enter interstate commerce?
Well, I think that what would be useful is if the FDA would simply promulgate regulations, which they already have the authority to do, to more clearly distinguish between traditional pharmacy compounding on one hand and drug manufacturing on the other. But to be honest, in a case like this, we're not in that sort of fuzzy gray area between the two worlds. We're so clearly in the camp of drug manufacturing that the FDA could take an action today. Really, all that's needed is the will. There was an FDA-approved drug out there that could have been used, and according to the FDA, it's in good supply. And so there's no reason for a pharmacy to be making from scratch under subpar manufacturing conditions products that could be purchased from a company that's complying with FDA regulations and actually has an FDA-approved product.
But we understand it may be the administration's way of keeping medical costs, healthcare costs down because the compounding centers are producing a product at a much lower cost. We'll get back to this again, I'm sure, as this case continues. Washington Attorney Sheldon Bradshaw is a former chief counsel for the U.S. Food and Drug Administration. We also heard from Boston Globe reporter Todd Wallack.
Here's a quote from the news. "What Lance said went." That was a fellow Tour de France biker echoing newly released evidence that Lance Armstrong organized widespread doping and evasion of official drug tests.
Next, the Sandusky sentence and preventing child sex abuse. For your ears only.